The Immigration and Nationality Act passed June 27, 1952 revised the laws relating to immigration, naturalization, and nationality for the United States. That act, which became Public Law 414, established both the law and the intent of Congress regarding the immigration of aliens to the U.S. and remains in effect today. Among the many issues it covers, one in particular, found in Chapter 2 Section 212, is the prohibition of entry to the U.S. if the alien belongs to an organization seeking to overthrow the government of the United States by force, violence, or other unconstitutional means. This, by its very definition, rules out Islamic immigration to the United States, but this law is being ignored by the White House. The laws prohibit entry of aliens who the consular officer or the Attorney General knows or has reason to believe seek to enter the United States solely, principally, or incidentally to engage in activities which would be prejudicial to the public interest, or endanger the welfare, safety, or security of the United States. It also prohibits the entry of aliens who are members of or affiliated with any organization that advocates or teaches the overthrow by force, violence, or other unconstitutional means of the U.S. or of all forms of law, and aliens who publish, circulate and distribute materials teaching or advocating the overthrow by force, violence or other unconstitutional means of the U.S. government or of all forms of law. Islamic immigration to the U.S. would be prohibited under this law because the Quran, Sharia law and the Hadith all require complete submission to Islam, which is antithetical to the U.S. government, the Constitution, and to the Republic. All Muslims who attest that the Quran is their life's guiding principle subscribe to submission to Islam and its form of government. Now the political correct crowd would say that Islamists cannot be prohibited from entering the U.S. because Islam is a religion. Whether it is a religion is immaterial, because the law states that aliens who are affiliated with any organization that advocates the overthrow of our government are prohibited. It also prohibits those who distribute literature that advocates the overthrow of our country, which would include the Quran. In fact, there are many verses in the Quran that command Islamists to kill those who do not submit to Allah and the Prophet. If Congress so desired to hold the White House accountable to the current immigration of refugees, which also must comply with the law, it has the Immigration and Nationality Act to cite. The administration is breaking that law. The question is, does Congress have the political will to do something about it? Or shall we be a nation like that in Isaiah 59:14 where justice is turned back, and righteousness stands afar off? For truth is fallen in the street, and equity cannot enter. I think you know the answer, at least for now. But there are a handful of congressmen who are studying this. Pray. To read the law, go to this link and scroll down to Chapter 2, Section 212. http://www.gpo.gov/pkg/statute-66-pdf/pg163.pdf. Have a blessed and powerful day. Bill Wilson, www.dailajot.com. PS. Please use the forward link below to pass this on to as many people as you can. Here is a reply we got on this post. Your blog of November 20, 2015, concerning Muslim immigration, is wrong. The Immigration and Nationality Act of 1952 was modified by the Immigration and Nationality Act of 1965. You are either 1. ignorant of that fact or 2. intentionally misleading people with the 1952 Act. Hopefully, it is the former, although many others are intentionally spreading the falsehood about the 1952 Act. This country has freedom of religion. That includes the freedom of individuals to be Muslim. No religious views, however, can be used to violate the law. Pastor Dewey note, a government official sent this to me. Jews. See United States Code, 2011 edition Title 8-Aliens and Nationality Chapter 12-Immigration and Nationality Subchapter 2, Immigration Part 2, Admission Qualifications for Aliens. Travel Control of Citizens and Aliens Secretary 1182-Inadmissible Aliens from the U.S. Government Printing Office, www.gpo.gov Paragraph 1182. Inadmissible aliens. A. Classes of aliens ineligible for visas or admission. Except as otherwise provided in this chapter, aliens who are inadmissible under the following paragraphs are ineligible to receive visas and ineligible to be admitted to the United States. 1. Health-related grounds. A. In general, any alien, I, who is determined, in accordance with regulations prescribed by the Secretary of Health and Human Services, to have a communicable disease of public health significance. 1. 2. Except as provided in subparagraph C, who seeks admission as an immigrant, or who seeks adjustment of status to the status of an alien lawfully admitted for permanent residence, and who has failed to present documentation of having received vaccination against vaccine-preventable diseases, which shall include at least the following diseases: mumps, measles, rubella, polio, tetanus and diphtheria toxoids, pertussis, influenza type B and hepatitis B, and any other vaccinations against vaccine-preventable diseases recommended by the Advisory Committee for Immunization Practices. 3. Who is determined, in accordance with regulations prescribed by the Secretary of Health and Human Services in consultation with the Attorney General, I, to have a physical or mental disorder and behavior associated with the disorder that may pose, or has posed, a threat to the property, safety, or welfare of the alien or others, or 2. To have had a physical or mental disorder and a history of behavior associated with the disorder, which behavior has posed a threat to the property, safety, or welfare of the alien or others, and which behavior is likely to recur or to lead to other harmful behavior, or I, who is determined, in accordance with regulations prescribed by the Secretary of Health and Human Services, to be a drug abuser or addict, is inadmissible. B. Waiver authorized. For provision authorizing waiver of certain clauses of subparagraph A, see subsection G of this section. C. Exception from immunization requirement for adopted children 10 years of age or younger. Clause 2 of subparagraph A shall not apply to a child who, I, is 10 years of age or younger. 2 is described in subparagraph F or G of section 1101 B1 of this title. 1 and 3 is seeking an immigrant visa as an immediate relative under section 1151 B of this title, if, prior to the admission of the child, an adoptive parent or prospective adoptive parent of the child, who has sponsored the child for admission as an immediate relative, has executed an affidavit stating that the parent is aware of the provisions of subparagraph A2 and will ensure that, within 30 days of the child's admission, or at the earliest time that is medically appropriate, the child will receive the vaccinations identified in such subparagraph. 2. Criminal and related grounds. A. Conviction of certain crimes. I. In general, except as provided in Clause 2. Any alien convicted of, or who admits having committed, or who admits committing acts which constitute the essential elements of, I, a crime involving moral turpitude other than a purely political offense, or an attempt or conspiracy to commit such a crime, or 2. A violation of, or a conspiracy, or attempt to violate, any law or regulation of a state, the United States, or a foreign country relating to a controlled substance, as defined in Section 802 of Title 21, is inadmissible. 2. Exception. Clause I shall not apply to an alien who committed only one crime if I, the crime was committed when the alien was under 18 years of age, and the crime was committed and the alien released from any confinement to a prison or correctional institution imposed for the crime more than 5 years before the date of application for a visa or other documentation and the date of application for admission to the United States, or 2. The maximum penalty possible for the crime of which the alien was convicted or which the alien admits having committed or of which the acts that the alien admits having committed constituted the essential elements did not exceed imprisonment for 1 year and, If the alien was convicted of such crime, the alien was not sentenced to a term of imprisonment in excess of 6 months, regardless of the extent to which the sentence was ultimately executed.